Hi, Larry Parman here, again broadcasting from top of a cruise ship, Viking cruise ship, up and down the Danube River. Now, real quick, I'm going to pick up on some more reasons why it's important to have an operating agreement if you own an LLC. So we talked about some in a previous broadcast, but the operating agreement can clarify decision making, can help prohibit deadlocks in the event that those come up, any ambiguities or questions that might occur between and among members. It also outlines the profit and loss distribution because depending on how you're being taxed, you might want some kind of a profit and loss distribution or allocation based on something other than tied to the percentage of ownership of each member. I mentioned earlier dispute resolution, that's important. Credibility with banks, that's very important. It can also customize the fiduciary duties that a manager has to the other members. Tax flexibility is important. LLCs can be taxed in one of four ways. If there's just one member, you can elect to be treated as what's called a disregarded entity. I briefly mentioned that in a previous broadcast. That would mean that everything flows straight through to your 1040. The default method of taxation for an LLC is as a partnership, where you have two or more members. The third option, though, is an LLC can elect to be treated as an S corporation. In some cases, that could be valuable, that could be useful. And then fourth, you can elect to have your LLC taxed as a C corporation. Now, that doesn't happen very often. In fact, I can't tell you the last time we created a C corporation, but in a few cases it can be very helpful. And then finally, continuity. What happens if a member dies, if there's a disability, if there's a divorce, if there's a bankruptcy or a lawsuit or any litigation that might negatively impact the ownership or the assets of the LLC? So again, very important to have provisions that stipulate what happens to that member's interest. There could even be buy-sell provisions included, so that if one of those events occur for a member, there are formalities about how that member's interest is to be treated, and the buyout provisions, the terms and conditions, and so forth. And then I'll just sign off with this. Some states, and I'm not going to hit them all, I know Missouri requires an operating agreement. I think Massachusetts might. In any event, you want to be sure that if your state requires it, you have an operating agreement. Finally, and this is my second finally, you don't always want the default statutory rules governing LLCs to apply to yours. Your written agreement can override those statutes in virtually every state, and that could be very important in terms of tailoring the way your property, the way your assets are going to be managed differently than might be outlined by state law. So again, a number of reasons. If you have an LLC, please, you should have an operating agreement to work in tandem with your articles of organization and other important documents that you have with your limited liability company. Anyway, signing off for now. You guys have a great day. It's starting to cloud over here a little bit. It's a little bit chilly. Not too bad, though. I'm sitting up here in a light flannel shirt with my sleeves rolled up, and I'm very comfortable. But anyway, I hope you guys are doing great. Look forward to visiting with you again, and I'll have more to say while I'm on the trip. Take care.
If you would like to learn more about creating an estate plan for your family, protecting your assets if you have to go into a nursing home, or transitioning your business, call 405-843-6100 or send an email to info@parmalon.com. That's 405-843-6100 and info@parmalon.com. Thank you.